Welcome back my YouTube channel NDS Shorthand. Please like, share and don't forget to subscribe the channel. Be ready. These legal rights may include contractual rights under certain circumstances in appropriate cases. The powers of the High Court under Article 226 are very wide, and the High Court may exercise this extraordinary jurisdiction in its discretion. In other orders, these are discretionary powers vested in the High Court. Now, dealing with the contentions raised by Mr. Paramjape, the first question that arises for our consideration is whether the liability of LIC under a life insurance policy is a statutory liability or a contractual liability. For answering this question, we have to analyze and interpret Section 45 of the Insurance Act 1938 because Section 43 of the Life Insurance Corporation Act 1956, among other things, provides that Section 45 of the Insurance Act shall apply to the corporation as it applies to any other insurer. Section 45 of the Insurance Act reads as under 45. Policy not to be called in question on ground of misstatement after 2 years. No policy of life insurance effected before the commencement on this act shall after the expiry of 2 years from the date of commencement of this act, and no policy of life insurance effected after the coming into force of this act shall, after the expiry of 2 years from the date on which it was effected, be called in question by an insurer on the ground that a statement made in the proposal for insurance or in any report of a medical officer or referee or friend of the insured or in any other document leading to the issue of the policy was inaccurate or false unless the insurer shows that such statement was on a material matter or suppressed facts which it was material to disclose and it was fraudulently made by the policyholder and that the policyholder knew at the time of making it that the statement was false or that it suppressed facts which it was material to disclose. An analysis of this provision of law shows that the insurer LIC in our case under the first part of section 45 cannot repudiate any policy of life insurance 2 years after it was effected merely on the ground that at the time of taking the policy inaccurate or false statement was made by the policyholder. But under the second part, if the insurer can show that such statement was on a material matter or the statement suppressed facts which it was material to disclose and that the suppression was fraudulently made by the policyholder and further that the policyholder knew at the time of making it that the statement was false or that it suppressed facts which it was material to disclose, then the insurer can repudiate the policy. In other words, under the first part of this section, the policy cannot be avoided by the insurer on the ground of inaccurate or false statement after the expiry of 2 years of effecting the policy, but the insurer can do so if it can be established that the statement made by the policyholder was not only inaccurate or false, but it was also on a material matter, or that it suppressed facts which it was material to disclose, and it was fraudulently made, and the policyholder knew at the time of making the statement that it was false to his knowledge, or that the facts which it was material to disclose were suppressed by him. Therefore, in my judgment, a correct interpretation of section 45 would be that under the first part of this section, the liability cannot be just avoided by an insurer after expiry of 2 years of effecting the policy.